Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is readily remembered as a great expounder and defender of the Constitution. Our resolution tonight is, should the court embrace the Major Questions Doctrine? We are thrilled to host Professor Chad Spiteri and Professor Ronald Levin to discuss this critical question. In addition, we are honored to have the esteemed Judge Rodolfo Ruiz, who left Florida's sunny weather for DC winter, to moderate. In addition, we want to thank Mr. Louis Capozzi, who was originally set to join us tonight and is a true friend of the Georgetown chapter. Unfortunately, he has come down with a cold, and we believe the administrative state may be to blame. We are deeply grateful to the Federal Society and to Georgetown Law to make the Daniel Webster debate series a reality. In addition, this is our last one of the semester, and I want to thank all of you for making such a great and memorable series. I now recognize Ian Stapleton to introduce these three stellar panelists. Please give them a warm welcome.
The Honorable Rodolfo A. Ruiz serves as a district judge on the United States District Court for the Southern District of Florida. Prior to his judicial commission on May 3rd, 2019, Judge Ruiz was a circuit court judge for the 11th Judicial Circuit of Florida from 2014 through 2019, and before that, a Miami-Dade County Court judge from 2012 through 2014. Judge Ruiz also served as an assistant county attorney with the Miami-Dade County Attorney's Office and as an associate with White & Case, LLP. He received Bachelor of Science in Economics from Duke University and earned his Juris Doctor from, right here, Georgetown University Law Center. After graduating from law school, he was a law clerk to the Honorable Federico A. Moreno of the United States District Court for the Southern District of Florida. Professor Chad Spiteri is Assistant Professor of Law at Catholic University of America, Columbus School of Law. Professor Spiteri joined the Catholic Law faculty in 2022 after having practiced law at Gibson, Dunn & Crutcher, LLP, as a member of the Appellate and Constitutional Law and Administrative Law and Regulatory Practice groups. He previously served as a special assistant to the former United States Secretary of Labor, Eugene Scalia, and as a law clerk to then Chief Judge D. Brooks Smith of the United States Court of Appeals for the Third Circuit. He serves as faculty advisor to the Catholic University Law Review and as managing director of the Center for the Constitution and the Catholic Intellectual Tradition. Professor Spiteri graduated from the University of Virginia School of Law in 2016 and Florida State University in 2013. Last but not least, as you can see behind me, we have Professor Ronald M. Levin. He is the William R. Orthwein Distinguished Professor of Law at Washington University in St. Louis School of Law. Professor Levin is a nationally known scholar who specializes in administrative law and related public law issues. Among his professional affiliations, Professor Levin has chaired the ABA section of Administrative Law and Regulatory Practice and served as the ABA's advisor to the drafting committee to revise the Model State Administrative Procedure Act. He also has chaired the section on administrative law and is currently a member of the Administrative Conference of the United States. Professor Levin clerked for the Honorable Judge John C. Godbold of the United States Court of Appeals for the Fifth Circuit, and he received his BA from Yale University and his JD from the University of Chicago Law School. So without further ado, for this last debate of the semester, I welcome Judge Ruiz for some opening remarks. If we could give our speakers one more round of applause, please.
Thank you for that warm welcome and introduction. It's also nice, I have a wife that's a Florida State alum, so I'm very glad my fellow panelist here is also a proud Seminole, I'm sure, although it's been a rough year for. I love to see it. So, well, first and foremost, it's great to be on. I was just telling Ian and Brady that this marks 20 years since I graduated, which makes me feel very old. I just got the save the date for a reunion email, so I really feel like it's been a long time, but my memories are so fond of being here at Georgetown. I know how busy this time of year is for all of you. I know there's a lot going on. We're on the eve of Thanksgiving, so having you all come today, really, it's an honor to spend this time with you, and I want to tell you how much I appreciate you guys coming out to join us for this debate. Again, my sincere thanks to the Georgetown Law Student Chapter of the Federalist Society for bringing me back to my home, to my old stomping grounds. It's always great to see so many familiar faces, and special thanks, of course, to Brady and to Ian for putting this program together. As I was telling both of them, it's a Herculean undertaking to run this many debates all semester. The logistics are daunting. It's really hard to keep things moving, keep the momentum going. I've watched many of the live streams and recordings of prior debates, and I know many of you have probably attended those debates, and I can tell you they've been fantastic. Every single one, all the resolutions have been great. It's been an incredible success for the chapter, and the chapter should be complimented for that. And I think it's always very important to remember that, you know, the whole purpose of these debates, besides obviously being dedicated, rightly so, to Daniel Webster, is they really do embody what Federalist Society stands for. And that's, you know, ensuring that you have these thought-provoking conversations with jurists, practitioners, academics, all of whom have one thing in common, and that's really just a profound commitment to the marketplace of ideas. And that's really the core tenets of the society. So again, it's, as we've already heard, we have wonderful participants in our debate, Professor Scuteri and Professor Levin, and it's going to be an honor here to talk to you all and answer a few questions about the Major Questions Doctrine. So our resolution this evening is specifically, should the Supreme Court embrace the Major Questions Doctrine? And I think we can all agree, certainly I'm sure it's changed the curriculum for many a professor in the last few terms. Wasn't much of a thing when I was here 20 years ago, I can tell you that. Some case law out there, which we'll talk about, but certainly not as formalized as we see it today. And the reality is, I think that the last few terms can only be described as a significant shift in the court's use of the doctrine. It's increased its prominence and its importance in the realm of administrative law, I think, really cannot be understated. So in order to properly frame tonight's discussion, I think we need to begin with a definition of what the doctrine is. So in its most simplistic formulation, the Major Questions Doctrine requires administrative agencies to identify, quote-unquote, clear congressional authorization to regulate issues of major political and economic significance. Now, although the principles underpinning the doctrine, as I mentioned, have played an animating role in cases in the past, such as FDA v. Brown v. Williamson, Gonzalez v. Oregon, Utility Air Regulatory Group, the EPA, and King and Burwell, I think we can all agree, especially with the 2021 and 22 term, that the Supreme Court formalized the doctrine and kind of assisted its evolution, if you will, into the modern approach that we've seen today. And that's one that treats the Major Questions Doctrine as a clear statement rule. And that's kind of how we call it now, as opposed to just a basis for withholding deference from agency interpretation. So how do we get here? All right, I think it's good that we kind of do a very quick diagnosis of what some authors have called the trilogy. Some law professors have termed it that way, kind of the explosion of the doctrine over the course of 3 cases in the recent term. No surprise, in my view, that some of this was hastened during the pandemic. I always think that there's probably a lot to that. Let's be all thankful we're here. We're not having to wear any masks, and we can actually enjoy each other's company. I can see your faces. That's a time no one wants to remember. I certainly don't want to bring it back into your memories. But we began with Alabama Associations of Realtors versus the Department of Human Health Services. And you may recall that addressed the CDC's attempt to impose a nationwide eviction moratorium in the midst of the pandemic. And the court made clear that, quote, Congress must speak clearly when authorizing an agency to exercise powers of vast economic and political significance. Given that the CDC eviction moratorium impacted millions of tenants, and emergency rental assistance had an approximate economic impact of $50 billion, the court ruled against the CDC. And in fact, Professor Levin, who I'm sure we'll touch on this a little bit, has noted in his writings that the clear statement version of the Major Questions Doctrine really began to make its influence palpably felt at the Supreme Court level with the Alabama Association's case, and again, coming to the court in an emergency posture, as we know. Then we move on to National Federation of Independent Businesses, the OSHA, and there, you may also recall that the court addressed OSHA's attempt to impose the COVID-19 vaccine or testing regime on most of American workplaces. And in that case, in rejecting OSHA's argument that the Occupational Safety and Health Act authorized it to impose such an emergency rule, the court held that OSHA could only address dangers unique to the workplace. As we've seen, I think Barrett always says is a little bit outside of the OSHA wheelhouse. It's kind of what how she's termed it, right? When we look at this case, we think to ourselves, well, COVID was no more prevalent in workplaces and in other indoor settings, and the court struck down the mandate in violation of the clear statement rule again of the Major Questions Doctrine. And in doing so, the court noted that the mandate was, quote, a significant encroachment into the lives and health of a vast number of employees. So you start to see a pattern, I think, We're talking about how much did it cost in the Alabama case, 50 billion, and now it's a lot of impacting a lot of different people. These seem like major kind of issues, right? So in his concurrence, Justice Gorsuch, joined by Justices Thomas and Alito, noted the importance of the Major Questions Doctrine, in that, like the non-delegation doctrine, a favorite of the justice, it ensures that, quote, the national government's power to make the laws that govern us remains where Article 1 of the Constitution says it belongs, with the people's elected representatives. Then we get to the case, if we will, in June 2022, the seminal opinion in West Virginia versus EPA, which is a self-described major questions case characterized by Justice Kagan in her impassioned dissent as, quote, the arrival of the major questions doctrine, right? Now, in curtailing the EPA's authority to regulate gas emissions under the Clean Air Act, the court in West Virginia, and again, a lot of it focused on some of the regulation of the Clean Power Plan, the court formalized, I think is the way we really envision that case, the major questions doctrine, which the Chief Justice described, and I want to make sure I get his quote down perfectly because it really encapsulates where we are today, quote, referring to an identifiable body of law that has developed over a series of significant cases, all addressing a particular and recurring problem, agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. And I think it's important, of course, identifiable body of law, because in the dissent, it was like, well, we're making this thing out of whole cloth. And as I've read to you, Gonzalez, FDA, not so. Might have formulated it a bit different with clear statement rule, but the underpinnings were there. And if you look at some of Justice Gorsuch's concurrences, he would say from the 1800s, the underpinnings were there. So this is not out of whole cloth. And I'm sure we will hear that from our panelists today and the debate over that. But in any event, the doctrine applies in, quote, extraordinary cases in which the history and the breadth of the authority that the agency has asserted and the economic and political significance of that assertion provides a reason to hesitate before concluding that Congress meant to confer such authority. So you got to remember, when you bring in a district judge, not my appellate overlords that are telling me what I did wrong, they grade my work. When you're a district judge, you're doing the people's work, you're on the ground floor, you're getting this thing right from the jump. You're making the record that my colleagues up in the 11th Circuit get to review. Judge Luck was here not that long ago. He gets to tell me all the things I did wrong. He's not afraid to do that. And I will tell you that one of the biggest things I'm going to talk about today, and I'm looking forward to the panelists getting into, is how does this really work? You know, how does this really work when the district judge, because let me tell you, it's happening. It's happening on my docket. Suddenly I'm getting, Judge, it's a major question. Great. So now we got to figure out what are going to be the steps. How are we going to do this? And, you know, I remember when I was in law school all the time, and one of the biggest kicks I had about any constitutional law provision or constitutional case was, well, you know, it's really funny how it seems to work up here. But then when it gets down in Southern District of Florida and Miami, it doesn't work exactly how my friends up here thought it would work until you actually apply it. And sometimes it can be a little tricky, the order of steps. What do you do? So in EPA, we hear a little bit about what are the factors relevant to the scope of the doctrines of applicability, the history of the exercise of the asserted regulatory power, and that's, of course, whether the agency used the power before, the breadth of that power. We've mentioned already the economic and political significance of the power claim, the degree of impact on the national economy, the degree to which Congress could have anticipated the agency's use of the power in question, whether previous legislative efforts to delegate the asserted power failed, whether the challenged exercise of executive branch authority would affect a fundamental revision of the statute, and whether the agency acted outside its wheelhouse. Now, when the major questions doctrine applies, it operates as a strong presumption that the agency lacks the claimed regulatory authority. And the court in West Virginia stated that a colorable or merely plausible textual basis, we're going to talk about how the major questions doctrine fits with textualism to begin with, because that's a strained issue there, and I think Justice Barrett really got into that when we're going to talk about the next case in Biden versus Nebraska, because she feels very strongly that it's consistent with textualism, and we're going to discuss that certainly today. But again, it can't just be a plausible textual basis. It's not going to suffice. We need something more. We need that clear congressional authorization, that clear statement. So Justice Gorsuch again concurs. He's joined by Justice Alito. He highlights the doctrine's clear statement rule as a method, again, of enforcing Article 1. The justice also offers guidance on how to apply the doctrine going forward. I, as an inferior court, can tell you it's one of the better formulations of what to look for. It's kind of like a to-do list, which I really appreciate from Justice Gorsuch. What are we looking at? Is it a political significance question? Substantial economic significance? What does that mean? Does it need to be billion with a B? Can it be 700 million? We'll find out. Or does it, I think one of the biggest ones we see sometimes is intrude into areas traditionally regulated by the states. And that gets into concepts of federalism. In dissent, Justice Kagan was quick to point out that the disconnect between the major question doctrine and textualism. Great line, as she often is, very sharp pen. When textualism would frustrate broader goals, special canons like the major questions doctrine magically appear as get out of text free cards, which is that's a great line. And so that brings us, as I mentioned, to Biden versus Nebraska, the most recent application. I'm sure that's also been taught many of you in common law now. It's another very seminal and important case, extending again and developing the major questions doctrine. As I'm sure you all recall, the court held the Biden administration lacked authority to cancel roughly $430 billion of federal student loans under the Higher Education Relief Opportunities for Students Act of 2003, or the HEROES Act. And in holding the HEROES Act did not authorize the Biden administration's loan cancellation plan, the court explained that language permitting the Secretary of Education to waive or modify any statutory or regulatory provision applicable to the student financial assistance programs did not encompass expansive authority to cancel student loans. Really, the case was a textualist case, really, at its core. I mean, we took a detour and got into major questions because it worked, but at its core, one could argue didn't really need to get into major questions at all. The argument really was the phrase waiver modify permits modest adjustments. It doesn't permit a full-blown cancellation, which would not only nullify existing provisions, but augment and expand them. But again, major questions doctrine gets invoked, focusing on, quote, concerns over the exercise of administrative power, and identifies loan forgiveness as a question of economic and political significance, and emphasizes the program's cost and politically controversial nature. Another one that gets me, because as I start thinking about the test, now I got to figure out what's politically controversial and what's not, and that's a very challenging thing, let alone figuring out what's major and what's not major, right? Now, concluding the major question was an issue, we go back to our phrase. The court held the Biden administration needed, quote, clear congressional authorization to justify the challenged program. So where are we at? Certainly, West Virginia and Biden versus Nebraska, they formalized, in my opinion, the major questions doctrine. It is certainly here to stay. All of you need to know it. If you don't know it, learn it. And the reality is there remains, as I'm sure both professors will point out, considerable debate on all sides of the spectrum, right and left, really even among the doctrine's proponents, quite frankly, on how and when to apply it in the future. And that's evidenced by Justice Gorsuch's concurrence in West Virginia, and as I mentioned, Justice Barrett's concurrence in Biden versus Nebraska. And this is where we get to my favorite comment before I turn it over to the professors. It's Justice Barrett's wonderful hypos in her concurrence, which just really connect with me personally. And I'll tell you the one that really connects the most. So, she worded it so well, as she said that the major questions doctrine situates text in context. So what that means is we are now finding a split a little bit about what really is it? Is it a canon? Is it a canon, or as maybe Justice Gorsuch has just sort of been very clear in Article 1 kind of vindication canon, or in the view of Justice Barrett, it's just textualism with context. We're supposed to read the text in context. That's part of what textualists do. And so she's very, very careful to avoid turning this into something it is not. And that's really, if you haven't read it or read it lately, I would urge you to go back, because her concurrence in Biden versus Nebraska really hammers it down. She doesn't approach the doctrine in the same way as Justice Gorsuch as a substantive canon. She views it differently, a tool for discerning, not departing from the text's most natural interpretation. That's her words. And has warned that the doctrine should not be taken from what it is, a familiar principle that we don't interpret a statute for all it's worth. What a reasonable person would not read it that way. And so what's the example I love? She brings up the rogue weekend babysitter. And she says, when told by the parent, quote, make sure the kids have fun, the babysitter takes the kids on a road trip to an amusement park where they spend 2 days on roller coasters and 1 night in a hotel. And the argument is, well, that certainly seems to be outside the scope of have fun when you give the credit card to the babysitter. I will tell you, I'm a parent of a 12-year-old and I'm a parent of a 9-year-old. If my babysitter took my children after I said, here's a card, which I'm thinking you're going to do to order pizza and maybe order a movie, you're not going to get in a hotel room or drive them to an amusement park. So I can tell you context definitely matters. That would not fly with me. I can assure you of that. So with that, I think we've set the stage and given us a brief evolution of what we're going to be discussing today. And again, should the court continue to embrace the major questions doctrine is our core resolution. The way in which I envision we'll give Mr. Levin the floor first, and then we'll hear from Professor Secretary. And I had a chance to read both of their writings, and I can tell you, I think, from Mr. Levin's view, Professor Levin's view, excuse me, you've noted that the doctrine's foundations on the non-delegation doctrine and other separation of powers principles is unsatisfactory, because you noted it doesn't supply a credible basis for distinguishing major rules from non-major rules. And I would agree that that's one of the biggest challenges, what's major and what's non-major. And certainly I look forward to hearing from Professor Secretary as well, who's going to, I think, certainly give us an argument for the continued development and increased prominence of the doctrine, but I would suspect will help us hopefully lay down some doctrinal markers to give us an even-handed application. Which again, for the inferior judge that's here today, that's what this is kind of a cheat code. Just ask the two professors, how do you want me to do this when I'm actually doing it? Because I'd love to hear their view on how this applies in the real world. It's a lot easier when you get into the nitty gritty and someone's telling you this is a major question. You should kick in your cannons and start doing it a different way. So with that, I want to turn it over to our wonderful professors. They have the floor. Professor Levin, I will turn it over to you first.
Okay, thank you very much, Judge Ruiz, and good afternoon, everybody. I want to thank Brady and the Georgetown FedSoc chapter for inviting me to participate in the Daniel Webster debate series, and I'm also happy to be appearing on the same program with Chad Squitieri. A bit of a surprise, but I do know his work, and I'm glad to be sharing the occasion with him. Now, when I think about Daniel Webster, it's in terms of the well-known Stephen Vincent Benet story that features Daniel Webster litigating against the devil. And in that metaphor, I assume that Chad is here as the representative of Daniel Webster, so it isn't hard for me to figure out whom I'm here to represent. But for better or worse, I intend to take on the role of devil's advocate in relation to one of my favorite topics, which is the major questions doctrine. And I'm drawing here on an article of mine that has recently been published in the California Law Review. So if I make broad assertions here that you are a little skeptical about, you can find the documentation of these claims in the article. So I'm going to uphold the negative side of the debate topic. And I'm going to phrase my critique of the major questions doctrine in terms of its legitimacy. Now, I'm well aware that one version of that topic has been the subject of well-publicized controversy recently in the, relating to the Society's National Convention. But I'm not here to challenge the overall legitimacy of current Supreme Court jurisprudence, which is the critique that a certain circuit judge ascribed, I think erroneously, to a certain member of your school's faculty. But I do believe the major questions doctrine in particular does raise questions about legitimacy. And that's because the court has not made a serious effort, in my view, to justify the doctrine and hasn't made any effort at all to define its boundaries. It is a distinctively, perhaps uniquely lawless body of case law, or so I will argue. But to clarify, my article doesn't say nobody could have a justification for any major questions doctrine. My article is only about critiquing rationales offered by the court itself or individual members of it. Well, the court came closest to trying to justify it in the West Virginia v. EPA case, which the judge mentioned. And Chief Justice Roberts devoted several pages to arguing that the court had already applied the doctrine in a host of cases. Well, Judge Ruiz, I think, has already explained that isn't really true. It had some precursors, but the clear statement principle, the one we have now, really didn't exist in the court's jurisprudence before the recent term in which West Virginia was decided, and that includes the Alabama and NFIB cases. Before then, it was a doctrine about deference, or there were cases that agencies lost, but the clear statement rule is an innovation. And we know the court does frequently overstate the teachings of its past cases. But I would say West Virginia was exceptional in the extent to which the court used somewhat exaggerated accounts of its case law as a substitute for analysis rather than a supplement for it. Well, the Chief Justice also relied heavily on what he said was a presumption that Congress itself would not use ambiguous language to confer on agencies the authority to adopt rules with a major economic and political impact unless it did that in clear language. But a serious objection to that reasoning is that in the past, the court has found many times that Congress did confer such authority. That was in statutes that use broad language like public interest, convenience, and necessity, or just and reasonable rates, or unfair methods of competition. And many of those laws were enacted by Congresses that were a good deal more liberal than the current court is. So what seems to be happening is the justices in the Supreme Court majority have created this presumption by projecting their own skepticism about the regulatory state onto the legislative branch. So I'm submitting that the court has not yet presented a more than perfunctory defense of the Major Questions Doctrine on the merits, but I do recognize, as the judge pointed out, that some of the individual justices in the majority have deployed more elaborate defenses of the doctrine in their concurring opinions. So I'm going to spend a little time discussing those opinions, specifically Justice Gorsuch's argument in the NFIB employee vaccination case, which is focused on the non-delegation doctrine, and Justice Barrett's concurrence in the student loans case, which relied on a so-called linguistic or contextual canon. Well, first, as to Justice Gorsuch's position, quite a few commentators do say that the Major Questions Doctrine seems to be an offshoot or variant of the non-delegation doctrine. But I see a number of problems with that equation, which may help to explain why the court as a whole has never endorsed that link. In the first place, the theory seems to rest on the vigorous non-delegation doctrine that Justice Gorsuch would like to see, rather than the essentially toothless non-delegation doctrine we actually have. Relative to that baseline, you can't explain the Major Questions Doctrine as constitutional avoidance because the statutes involved have no constitutional problem that needs avoiding. And moreover, suppose we assume for the sake of discussion that the non-delegation doctrine at some point gets reinvigorated. A serious difficulty with Justice Gorsuch's theory is that it doesn't provide any satisfying basis for distinguishing major questions from non-major questions. If Congress's decision to delegate authority to an administrative agency is constitutionally suspect, logically that problem would seem to exist, regardless of whether the resulting regulation would be expensive or not very expensive. So Justice Gorsuch tried to get past that problem by relying on a dictum that Chief Justice John Marshall wrote in an early case, Wayman against Southard, exactly 200 years ago, 1825.
If you can hear us, Professor, we lost your audio for a second.
Let's see what I can do about that. Do you hear me now?
Is that ours or his? Ours looks okay.
You made it through the state again.
Oh,
You might rejoin.
maybe he'll rejoin for a second.
I may have to
We can hear you now, Professor. We can hear you now. If you want to keep going, maybe it's easier just with the audio, but we hear
Okay,
you.
what did you hear last?
I think you had cut off where you were saying difficult to tell non-major from major questions. Just around
Yes.
there.
It's difficult to tell the two apart. And I don't think the non-delegation theory that Justice Gorsuch offered solves that problem. He tried to solve it by relying on an 1825 dictum by Chief Justice John Marshall. But that dictum, which said some important subjects can't be delegated, didn't explain where he got that distinction, what that category would include. And in 200 years, the court hasn't elaborated at all on what matters would fall into that category. So I think it's quite a stretch to contend that this long neglected dictum can provide authoritative support for a newly created judicial review doctrine in the 21st century. So then I get to Justice Barrett's concurring opinion, which outlined what she said was a a contextual canon, which would amount to applying common sense to questions about the breadth of the delegation. But the problem with that is that common sense is so much in the eye of the beholder. Justice Barrett claimed that all of the court's holdings in the major questions doctrine cases can be explained on the basis of her theory. But in all those cases, the court was deeply divided, so her theory seems to assume that the conservatives on the court possess common sense and the liberals don't. You can believe what you want about that proposition. I imagine if I took a straw poll in today's room, we know how it would come out. But I don't think a jurisprudential approach that rests on a premise like that can be viable. So if none of the rationales put forward by the majority holds water, what's really going on? I want to suggest what I believe the majority probably thinks it's doing in these cases, although it hasn't said so. It probably thinks of the major question doctrine as a substantive canon, which is adopted as an exercise of its power to create administrative common law. And unlike the theories I've already discussed, I think that explanation is internally coherent, but it has a significant problem of its own, which is a problem of legitimacy. It basically amounts to the majority justices writing their own ideological preferences into the fabric of administrative law. And that move is very hard to reconcile with the justices' often repeated assurance that they sit to enforce neutral principles of law and not to implement their own value preferences. To illustrate that problem, my article put forward a thought experiment. Suppose a liberal bloc of justices gained control of the court and adopted a clear statement rule to the effect that no major rule that tends to perpetuate racial inequity can be adopted without clear congressional authorization. Its proponents could claim that that implements the spirit of the Equal Protection Clause, which would be at least as plausible as the theory that the Major Questions Doctrine implements the spirit of the non-delegation doctrine, or maybe more plausible because of the quiescent state of the non-delegation doctrine. But anyway, I think conservatives would react to this hypothetical canon by saying not only they disagree with it, but also the court had done something illegitimate by writing its value judgment into the case law and statutory interpretation. They would be absolutely right. And in my view, the real Major Questions Doctrine can be criticized for essentially the same reason. One final basis for objecting to the Major Questions Doctrine is that its outer boundaries are completely undefined. And supporters of the doctrine could say, well, that's a cheap shot because plenty of doctrines in administrative law are ill-defined as well. Like, what does arbitrary and capricious mean? But I contend the Major Questions Doctrine is unique in at least one sense. None of the justices who support the doctrine has ever written even one sentence in any of their opinions to tell us what circumstances would not trigger the doctrine. The court literally acknowledges no limits on its prerogative to decide what is or is not a major question. You just can't find it in any of those opinions. Now that particular question, that objection to the Major Questions Doctrine can't last forever. Sooner or later, the Supreme Court will encounter a rule that a lower court is set aside by applying the doctrine, but the justices themselves want to uphold. And when that day comes, the court may have to articulate some reason as to why that rule doesn't violate the MQD. But that could turn out to be a difficult task because the court hasn't yet developed a defensible theory as to why the doctrine exists at all. So to conclude, I don't expect the Major Questions Doctrine will go away anytime soon, but if people come to appreciate the extent to which the court's creation of this doctrine has been unexplained and maybe is illegitimate, the court might feel pressure to apply the doctrine with greater restraint than it has yet shown. And if the court wants to respond constructively rather than defensively to complaints about legitimacy, the Major Questions Doctrine would be a good place to start.
Thank you for that, Professor. Professor, the floor is yours. Great. Well, thank you first of all to Georgetown and for those having me here. I agree that this is a very well run event, so you all should be very proud of that. Thanks also to my friend Lou, who of course was supposed to be here tonight, but is sick, so you guys are missing out on hearing from him. But I figured when he asked me today, do you want to come join us? I thought, well, I can do two things. One, I could come in and speak with these fine people, or two, I could
sit in my basement and think about the major questions doctrine anyway. So I figured I'll come here and think about the major questions doctrine with you. And then finally, thanks also to Judge Ruiz, who it's always nice to see another Floridian. And I'll say this as a compliment, and I don't think you'll take it as one. But when you were describing major questions doctrine, I thought you sounded very much like an administrative law professor. So for those students, it was very precise and with your descriptions. And for those students studying for their admin law exams, I'd recommend going back and listening to those descriptions. The litigants that come before you should be proud and happy to have a judge that cares so much about this developing area of the law. So I'm going to take, and also thank you to Professor Levin as well. I would like to take, I guess, a qualified positive side on this debate, and that is that I'm a textualist, and I think that textualists should object to the major questions doctrine, at least as it has been defended to date. But I think that you can reformulate the major questions doctrine into a way, into a form of something that textualists can indeed embrace. So where I'm coming from is I like what the major questions doctrine is seeking to do. When I look at the administrative state, I see a lot of unlawful delegation agencies running wild in some instances. But I think as a textualist, you need to maintain committed to your interpretive principles. And that's where I'm coming from in this debate. So why do I think that the major questions doctrine as it currently exists cannot be accepted by textualists? Well, for this, I look to the two justifications that the court has given for the major questions doctrine to date. And I think we get a nice, crisp analysis of this in the West Virginia majority opinion from Chief Justice Roberts, where he says, in certain extraordinary cases, both one, separation of powers principles, and two, a practical understanding of legislative intent, make us reluctant to read into ambiguous statutory text the delegation claimed to be lurking there, to convince us otherwise something more than a merely plausible textual basis for the agency action is necessary. The agency must instead point to clear congressional authorization for the power it claims. So I see in that two justifications for the major questions doctrine that has been elaborated on the additional opinions that Professor Levin has flagged. Those two justifications being separation of powers principles and a practical understanding of legislative intent. So let me explain why I think a textualist can't really sign on to either of those. So as to separation of powers principles, I think that is too broad of a concept. Why do I think that's too broad of a concept to support a substantive canon? Well, then Professor Amy Barrett said so in a very influential law review article when she was a professor, before she was demoted from being a professor going on the Supreme Court. But she says, the separation of powers is too broad of a conception to support a substantive canon. Separation of powers is an idea of multiple different principles. Perhaps one of those could support a substantive canon, but not just a separation of powers in general. So to be more charitable, perhaps there is a particular part of the separation of powers that could promote the substantive canon, such as the non-delegation doctrine. And I agree with Professor Levin that that is what we see in the Justice Gorsuch concurrence in West Virginia. In particular, he's saying that a particular version of the non-delegation doctrine, that line we get from Wayman, the important questions test, well, perhaps that, in enforcing Article 1, perhaps that can serve as a basis for a substantive canon. But I think that's unsatisfactory as well, in part because, as Professor Levin mentions, that version of the non-delegation doctrine is not the law. So if you want to change that version of the non-delegation doctrine, which I think the court should do that clearly, but should not do that kind of through the back door in a major questions doctrine case. And in addition, even if the court were to change the non-delegation doctrine, I don't think they should change it in the line that Justice Gorsuch is referring to here with the important questions test, in part because I think that gives too short shrift to the president's role in the lawmaking process, and I'll come back to that in a second. So that's my objection to the first justification. What about the second justification, which again is a practical understanding of legislative intent? Well, I think a textualist has to object to that as well, in part because textualists typically do not believe that Congress has an intent, an identifiable intent. So this reference to a practical understanding of legislative intent, that must mean some sort of linguistic canon that's capable of deriving an objectified intent from a statute, which is indeed what statutes do. And indeed, a follow-on case, Nebraska, the student loan case, we see Justice Barrett elaborate on this point, and indeed she refers to this as a linguistic canon. I think nonetheless that is still objectionable. So I take the judge's points about the babysitter example, and I think Justice Barrett is onto something when she refers to examples such as that. But I think the problem is when she tries to take that linguistic conception that might apply in a world of parents and babysitters, and then bring it over to the specific situation of how statutes are made. And I think the problem there is that she, in short, the president is a parent as well. Later on in her statute, she says the babysitter situation would be different if the babysitter was, another parent. Mom's going out of town on a business trip, and she tells the dad, who's referred to as a babysitter here, make sure the kids have fun. She says, well, of course, the dad in that situation would have more major authority. And I think that is the situation we have in the federal lawmaking process. How? Well, the president plays at least two important roles in making federal law. One, in Article 1, Section 7, the president influences legislation through the veto process. And even the mere threat of a veto can require Congress to alter legislative language to adjust to the president's legislative preferences. And two, the president can also recommend legislation through the recommendation clause of Article 2. So because the president can influence legislation, I don't think a textualist jurist who should, in my opinion, should be a faithful agent of the people, not a faithful agent of Congress, and not a faithful agent of the president, a faithful agent to the people. I don't think a textualist jurist can favor the legislative intentions, desires of Congress systematically over the president. The president might often say, yes, I will agree to make this statute with you, Congress, but I am going to claim major authority for my administrative agents exercising executive power on my behalf. So that's my objection to the Major Questions Doctrine. What do I think we can do about it? Well, I have a proposal in a law review article I wrote that relies on the recommendation clause in particular of Article 2. So how should textualists think about federal legislation? I think textualists should think of federal legislation as the ultimate legislative compromise that survives a series of intra-political debates within the two chambers of Congress, and inter-political negotiations between Congress and the president. Textualists are really good at acknowledging the first one, really good at saying 535 legislators have different ideas about what's major and what is important and yada, yada, yada. Textualists don't do as good job as recognizing that the president also has very important ideas in this context as well. Presidents can influence legislation throughout, like I said, just merely even having the veto authority. I think of it as different presidents having essentially different strike zones, so to speak. Congress knows, okay, this particular president will accept these types of things and not accept those types of things. So we're not even going to send something over to the White House, or if we are, we're going to have to adjust the legislative language to ensure that we get a substantial majority of Congress that it can survive and overcome a presidential veto. And the president can also influence legislation through the recommendation clause, which gives the president a first mover type advantage. For example, the recommendation clause, which is right next to the State of the Union clause, that's one moment when the president can make recommendations at the State of the Union. Think about when the president makes some legislative recommendation at the State of the Union, half the country talks about how great it is, half the country talks about how dumb it is, but the power of just being that first mover and getting that recommendation on the table is important. The recommendation clause is in Article 2, Section 3. It says the president shall recommend to Congress's consideration such measures as he shall judge necessary and expedient. And as I lay out in the article, this is both a power, the power to recommend to Congress, and a duty. The president has to, when the president sees something that is necessary and expedient, has to bring that to Congress's attention so that he can hammer out a solution with Congress. But it's also just to bring it to Congress's consideration. The president cannot say, here's something that's necessary and expedient, and I'm going to do it myself. And that is where I see the kind of trigger for my reformulated Major Questions Doctrine. So let me end by talking about how that would work. Well, step one of this reformulated Major Questions Doctrine would say someone who's concerned about a regulation Well, actually, before I get to that, what would stay in my model? What would stay is a focus on prohibiting the president from squeezing new powers out of old statutes. Right, that would stay. The idea would be some sort of political compromise was hammered out in legislation that gave the president some sort of powers. You might assume that the president definitely claims some major powers for his agents. Sometimes maybe not. And the president gets that and only that, and can't squeeze out new powers out of that. So that part of the major questions doctrine would stay. What would not stay are federal judges having to determine whether something is politically major, right? In part for some of the reasons that Judge Ruiz mentions, I think that is pretty hard for a federal judge to determine what is politically major. And indeed, I would suggest that federal judges of all professions are at the it's more difficult for them to determine what is politically major than just the average person on the street, because judges are intentionally insulated from politics. We want them to be acting in a way that's almost not oblivious to politics, but definitely not always front of mind. So I don't think they are really the correct people to be reading the political wind. So that would be gone from the reformulated doctrine. Step one of the doctrine would say that a challenger would say, okay, look, the president has done something. That is a, quote, unheralded power from a, quote, long extant statute. That's language from existing major questions doctrine cases, essentially just saying, look, this is an old statute. The president's trying to do something new. Look very closely at this, judge. Step two, the president could then get out of that by saying, well, no, this challenge action was not a necessary and expedient action, not something that the recommendation clause would require me to bring for Congress's buy-in. And I think there would be reasons that a president would be hesitant to say, no, this is not necessary and expedient, therefore get out of the litigation. For one, it would place the president in quite an awkward political spot to have his agents go into court and say, yes, the president thinks that this regulatory action is very important, so important to impose regulatory burdens on people, but the president doesn't think it's necessary and expedient. That would be politically problematic. And then step three, we would ask, okay, even if it was necessary and expedient action of the sort that the president is supposed to take to Congress, not to act unilaterally, is the president excused from doing so because the president already has, quote, clear congressional authorization, right? Which is again part of the existing major questions doctrine. And to determine that, we could use some of the very factors that Judge Ruiz mentioned in the Justice Gorsuch concurrence, and I won't get into that now, but that is how I see a reformulated doctrine being able to work. And I'll stop there, and I'll look forward to questions and follow-up.
Thank you, Professor. Professor Lemon, I would turn to you just if you wish. I have some questions here certainly that I'd like to get into, but I don't know if there's anything you want to add in terms of a rebuttal to Professor Secretary's view on how to kind of reshape or reformulate the major questions doctrine.
Well, I'll just make a short comment on his proposal, and it seems we see eye to eye on a number of critiques of the way the court has articulated the doctrine itself. I would think that a standard textualist analysis would say the text has to speak for itself. It is probably the resultant of interactions between Congress and the president, but ultimately they agree on some text. The president signs off on what the branches have passed, and so at that point, you look at the text. I think that's a standard textualist analysis. And if I were a textualist, which I'm not, I would think that is pretty straightforward. But all it would show, I should think, is that you need support in the legislation. Or to put it conversely, a court would set aside the agency's rule if it exceeded the authority of the conferred by the statute as the court interprets that statute. That's just standard ultra vires doctrine. The problem is, how do you get from there to the proposition that you need clear congressional authorization? Sure, you need congressional authorization, whether you get that, you find that authorization through textualist means, purposive means, or anything else. But why it has to be clear, I think, doesn't really jump out from the theory that we have here, and that's the weakness of the major questions doctrine, in my view.
Do you want to add anything to that, Professor?
Yeah, I'll briefly add. Thank you very much for those remarks. As far as how we determine whether clear congressional authority would be had, I would actually call it clear statutory authority because I don't like thinking of just the Congress enacting a statute. But I think we could, like I said, just use the factors that we get from Justice Gorsuch's concurrence, and I'll just briefly explain 3 of them here and why I think those are textualists. One is focus of the statute in relation to the problem the agency seeks to address. There's been work that I relate this to the mischief rule. That's not my theory. Professor Sam Bray has written about that. And the idea is that you can embrace something like the mischief rule as a textualist. So focusing on the statute in relation to the problem that it's trying to address would help you show whether there's clear congressional authorization. The second thing is the agency's past interpretation of the relevant statute. I think that helps inform original and public meaning in at least 2 senses. One, it shows original public meaning in general, what just somebody thought, happens to be an administrative agency, what they thought, but it also shows a very important original public meaning, the understanding of an expert at a particular time, right, the agency. And then finally, the mismatched expertise point. There, I think that can help us determine, okay, if an agency is trying to do something that it doesn't have expertise in, that suggests that there's not some clarity in the statute about this, and it might be a really good idea for the president to take an agency in a new direction to accomplish a new problem. But the president needs to seek the congressional buy-in to do that, because Congress might say, we're not going to give you all you want, or Congress might say, we're giving you what you want and more, because we care about this problem more than you. So those are kind of the 3 factors I would use to figure out congressional statutory authorization. But again, I appreciate the response.
Thank you for that. So we have a little bit of time for some questions. I'll tell you, we touched on a lot of things that bother me, and I think Professor Cottrell, you kind of hit it on the head. As far as I'm concerned, what is a textualist jurist to do? Because that's my problem with the doctrine, in that I'm looking for benchmarks in terms of application. And this, when I first read the opinion, it felt like I was Potter Stewart with obscenity. You know when you see it. It's major. That to me is so problematic, because I can see skilled litigants are going to come before me on major issues that arise in my state, which is no shortage of legislation that gets challenged on a regular basis, and try to throw at me that this is a major issue or a major question. So I'm going back to your earlier point. You were saying squeezing new power out of an old statute is I think that's a really good way to do it. I guess my challenge is we are so focused, and Professor Levin said it too, on looking at the text and not straying. And so much of the test looks to all these other extraneous factors that we try to avoid, like, oh, well, Congress fought over this before and they never got a deal done. Or the president said it's a super big emergency because we have the pen. It's just, I'm being asked to look at all these extraneous factors, which I detest. I mean, the whole point of why I'm a textualist is I don't have to do that, because it's impossible, because any of us can do value judgments. Professor Levitt, what's important in the universe? I get to pick and choose what I want. So how do we tether ourselves so that the text doesn't get pushed to the side? That's my biggest problem, because I know it's going to be in front of me, and I'm not certain how I can hold the line without being asked to look at all these extraneous factors that just kind of run afoul of the fundamental tenets of textualism. What do you think? How do we do that? What's that tension like?
Yeah, so I definitely appreciate the tension. I think the doctrine puts district courts in a really hard spot, because someone just comes in right off the bat and says, "Look, Judge, here's a news article. This is a big political deal, right?" And you say, "Go to Congress. Why are you here?" And your point about the obscenity, when Judge Kavanaugh was on the D.C. Circuit, he referred to the Major Rules Doctrine, which is the same thing, and he actually used the line. I know when you see it type thing. So correctly, if I were to try to defend it as best I can, and I would say that all of those kind of extraneous things, what a textualist judge should be doing is looking at them and saying, how does this help me determine the original public meaning of the statutory text? I can use the evidence up to there and no further. And indeed, I don't think the court has suggested to not do that. I wish they would have been more clear about it. So, for example, like legislative history, Congress has debated about this in the past, right? Textualists traditionally say we don't like legislative history because we care about what makes it into the statute. But I like the way Justice Barrett actually recently said it. We had her on our campus at Catholic Law, I don't know, maybe a year ago now. And she said, Justice Scalia was on the court at a time when legislative history was all over the place. So he kind of thought of it as, the mere occasion of sin. Like, let's not even get close to it. But if you think of it theoretically, you can, as a textualist, use legislative history up to the point that it informs the original public meaning. So things like that, okay, yes, Congress debated it. Why does that matter? It might help me figure out what this particular statute means at a particular moment of history. And then you just have to restrain yourself from using it more than that. But I agree, and don't envy the task.
Professor, let me ask you on that point. I mean, Justice Kagan, in one of the dissents, she kind of has like a guy called like a Kagan two-step, where it says number one, is the agency trying to resolve a major question? Number two, did Congress clearly authorize agency's action? That's kind of how she's formulated it, right? And certainly I'm in agreement with both of you that we need to refine it. Whatever iteration is going to be the applicable one down the line, we haven't had enough of a test case. For example, you mentioned we need to see one where someone finds something is major and is swiftly rebuffed by the court and told, no, you've overextended it. That'll help give us some guidance. But let me give you that same question. With the way the law is at the current moment, and it's being applied at my level, at a district court level, what would be your formulation to try to do it? Would you suggest trying to look at the text and not stray at all so that you don't get into those waters, you can avoid it? I'm trying to get a sense of, as it's currently construed, what should we be doing?
Yeah, it's not easy for me to answer that question since I'm not a supporter of the Major Questions Doctrine.
But think about it this way, Professor, I got to do it anyway.
I understand that. Yeah.
I don't have a choice, right? So that's
really, no, I sympathize.
Whether I like it or not, I'm the lower court. I got to follow it. So what do I do?
I sympathize with your situation, and I can tell you, you're not alone. I've seen articles about the way lower courts are responding to the Major Questions Doctrine, and they don't feel they know it when they see it. They are really perplexed because the court has not said really very much at all about what the boundaries of this doctrine are. So how are they going to approach it? Well, if you're committed to textualism, then I would follow textualist principles and not apply a clear statement presumption, because I think that's somewhat at odds with the standard textualist logic. So I think that's an inherent difficulty that Justice Barrett does not overcome, because she says she's only applying a linguistic canon, but then she goes on to explain that this ordinary common sense reader believes all these things that conservatives believe, but liberals don't also believe. And so I think there's a real substantive element in her theory, but the difference is she doesn't acknowledge it. The majority does acknowledge it. They say we are adopting a substantive principle, which I think is candid, but I don't think well-founded.
Do you think, Professor Levin, there's a way, district judges get really good at punting? So when things get a little bit dicey, my few colleagues, and I did some research for coming up here, and I've seen it emerge, and district judges have not fallen for it, if you will. And the way that some of my colleagues have attempted to do is just say it's so rare and so exceptional. I mean, the magnitude of it has to be, if you look at our sample of cases that we've had where it's developed, right? The moratorium, student loans, the economic impact, the national scope. Do you think there's a way for those that are not proponents, because, our resolution is should it be embraced, to cabinet so that it becomes a doctrine that is just used so sparingly that unless it is the case of the century on my docket, the odds of me biting on a major questions argument are 1% or less. What do you think about, and again, this is a very practical way to approach it, but I'm just curious, do you think it might be coffined just because all the cases that seem to rely on it are of such economic and national importance that it just is not a one-off type of scenario? It's got to be at that level. Do you think that will help restrain it in a way?
So I want to be serious and not just take pot shots. But I think I would recommend that you do your best to figure out how the statute can be interpreted without regard to the major questions doctrine. And that actually is what happened in the student loans case. The court reasons through a statutory analysis, and then at the end says, oh, by the way, the major questions doctrine can reach this result too. I think if you, as a lower court judge, will use your best powers of legal analysis to answer the question without regard to the major questions doctrine, and then speak to whether that doctrine may also apply, I think you'll be given the most help to the appellate court and to the public about how you're reading the statute, instead of pulling out this mysterious doctrine and saying it trumps ordinary principles of interpretation.
I would agree with you there, because I think in that case, as we mentioned earlier, I mean, it stands on its own on a textualist analysis without the need for major questions.
Yeah, I think the court could easily have reached the same result in the Alabama case without mentioning the doctrine. I think they just didn't believe that the CDC statute applied to evictions. They could just have said that. They didn't need this crutch.
Well, and I will say this, I don't know if Square you mentioned, I think one of the easiest formulations for me has been the wheelhouse concept, because that was a big driver, right? The same thing with OSHA. You know, it's when it looks like it's just so outside the expertise of the agency, it doesn't really fit. I think that, but let me be clear, I think you still need all the other impacts, right? I can't just say, well, the agency's gone out of its purview, unless it triggers a huge downstream consequence. I don't think the doctrine comes up at all. But it just seems to be a starting point. I don't know if you think that way. You mentioned earlier, is this something that this agency has never done? I mean, they have no expertise in this area, right?
Yeah, I agree with that, and precisely how you said it. And there was a little back and forth between Gorsuch and Justices Gorsuch and Kagan in West Virginia about whether you needed that. So I think your way of approaching it makes sense. I'll just add one point that on the substantive canon point, I think some of the best work I've seen on this was then Professor Amy Coney Barrett, and she kind of explains how textualists can embrace a substantive canon in her article. I think it's called "Substantive Canons and Faithful Agency," and what she's written in Student Loans does not go against that. She's just talking about a separate thing. She's talking about a linguistic canon there. But I think just reading her works, I find it very insightful, would kind of help jurists think through it.
And let me ask one last question. How much, if any, role does an ambiguity play in this analysis? Because, you know, it looks a little anti-Chevron-y at moments when you see the way that's been formulated that I have a problem with. But again, I don't, because I think to Professor Levin's point, some of this is atextual or doesn't really rely on it. Doesn't seem that ambiguity is really going to play a role unless there's ambiguity about the clear congressional directive, which is my other fear, which is, you know, how clear does clear need to be? Because that's the other challenge. I mean, I'm going to be parsing through a statute if that's really the test that's formulated and figuring out, was Congress given a directive that they want this agency to be handling this? There could be ambiguity in that directive, and then that begins to go right back to, well, textualist principles are going to inform me. Do you have any thoughts? Let me ask Professor Levin on that. And I know this is obviously, Professor Levin, from a big picture, I know you point out the flaws quite well, but with its current state, do you think that the ambiguity of the statute really, because it is referenced by the chief in West Virginia, he talks about an ambiguous declaration or ambiguous conferring of that power by Congress or that subject matter expertise. Do you think there's a role to play with ambiguity when you go through it?
Well, so I think you have to juxtapose this case with Loper-Bright, because in Loper-Bright, the court said, oh, sure, some statutes look ambiguous, but you just have to do your darndest. You can't defer to the agency just because it's ambiguous. So do your best, as courts do in every field of law, administrative and otherwise, and work through and give it your best shot. And that is, I think, the message of Loper-Bright. In West Virginia, the court, I think, is saying something different, which is if it's ambiguous, the agency loses. And just as this is a FedSoc meeting and it's a forum for provocative ideas, I want to raise the question of whether Loper-Bright overruled the Major Questions Doctrine sub silentio, because the court said in that case that the APA, Section 706, makes it illegal for a court to follow a pro-agency presumption. And now the question is, if that's what they think, how can they say that it's consistent with an anti-agency presumption? If Section 706 requires the agency to use its independent judgment and cannot adhere to the presumption that they followed under Chevron, I don't quite see how they can then turn around and say we're going to follow a clear statement principle, which is not what we would have reached through our independent judgment. I'm being provocative here, of course, but that's what I think this meeting is for. So I leave that for your
That is what it's for.
agitation.
That is what it's for. Let me Professor, do you want to touch on that on the show? Because I will say that I think the sequencing of Loper Bright is really interesting. This kind of heralded, in my view, West Virginia heralded what Loper Bright was in many ways, but because now it's weird to have a presumption against regulation in a major questions doctrine after Loper Bright. So I get what Professor Levin is saying, and so I wonder, do you think it has impacted the way we look at the test at all?
Yeah, I get Professor Levin's saying as well. I'll state that my opinion is no, Loper Bright did not overrule the major questions doctrine for two reasons. One, because the major questions doctrine around the COVID era really broke away from Chevron and became its own thing. So the demise of Chevron doesn't affect it. And two, I would just quibble slightly. So we finally get some debate, Professor Levin. I will quibble slightly that the major questions doctrine is similar to Chevron. It's not similar in the opposite. It's not like Chevron requiring a court to forego its independent judgment and defer to the judgment of another. It's just saying, independent court, when you are using your independent judgment, here is one interpretive tool, like the rule of lenity, say.
Then what is the word clear doing in this? You could leave the word out and say, yes, apply your, look for congressional authorization. But the word clear, I think, does betoken what the court says it is, a clear statement principle. And that's where I think there's a little bit of a difficulty. Not that I really believe that the major questions doctrine has been overruled, but I do think that the Section 706 analysis in Loper Bright can't be correct. And if only the court had heeded the well-reasoned amicus brief that I and some other issued that says Section 706 is irrelevant, they wouldn't be in the problem that they have now.
Well, with that, I think we're just about at time, but I do want to give both of let's give both of our professors a round of applause again. That was excellent. And just for any closing remarks, I'll start with you, Professor Levin. Anything you want to close with here before we conclude?
I think I've said enough. I will say this: the babysitter analogy is a very interesting one, but Justice Barrett borrowed a whole cloth from an article by Elon Werman. It was his idea, and it would have been nice to attribute it to him, but I think he should get some recognition here.
Well, I will say, Professor Werman, who I've had an opportunity to read some of he has a piece in the Virginia Law Review recently that touches on this tension, I think, with textualism. And I think similar, I know he drew on some of your work, Professor Guattari, is trying to reformulate, because he's acknowledged some inherent problems as well. But I didn't realize we didn't give him credit for the babysitter thing. So I feel bad. He should get credit for that. But anything you want to finish or add as we close?
Yeah, just thank you all for having me here today.
I'm sorry we didn't get a chance to have questions, folks. We're a little over time, and I know how busy all of you guys are. But I want to thank everybody again for coming this evening, and thanks again to both professors. I think this is a wonderful debate. And you guys, I want to just emphasize that you come to these types of events, and perhaps sometimes you wonder that it's very academic, or it's not applicable, or you're not going to do it, or you're not going to see it. One of the things I want you to walk away from today is you have someone here who's living it, professors who are writing and analyzing it, and you will go litigate it. And this really will develop in your time. So don't make no mistake. The vehicle for getting to where it is starts at a district court trying to apply this. And so to the extent you wonder, well, how much of this is really going to ever matter in the way I practice law? You'd be surprised. And so I want you to walk away understanding that these debates are real, they're ongoing, and this doctrine has a long way to go. We're just getting started with this one. So thank you guys again for coming this evening.
Thanks, everybody.
Thank you again, Professor.
Thank you, Professor. And everybody, one quick housekeeping item. We're officially done for the semester. So, thank you all. What a great